Well, hello class. Welcome back from spring break. I hope you guys had an amazing time while you were away. I didn't get a lot of emails asking about the midterm, so hopefully that means that you were just enjoying yourselves and everybody's feeling all ready. And thanks to Jared for being there tonight to cover the class, and hopefully this video comes out okay. And anything that's covered in this video will not be on the midterm, and you'll be able to ask some questions about it when I'm back with you next week. So please take notes and write down your questions, and we'll make sure to do a debrief about this and make sure we cover anything that will be on your final later on. So let's get started. Tonight I'm going to be doing a brief lecture about human resources in the church. We're going to talk about the church as an employer and some of the specific things, laws, regulations, and so forth that pertain to religious organizations and specifically religious nonprofit organizations with respect to our requirements when we employ people. So whether you end up leading a church or whether you are running a parachurch organization or you end up running your own business, at some point you're going to either be an employer, be an employee, or be someone that needs to interface with this information. So the learning objectives for tonight are first to be able to identify the main requirements for employers in the hiring process. When we do a good job of hiring people, then it really saves a lot of headaches later on. And as you know, in the book Execution, we've been reading about a core process called the people process, which speaks to the importance of identifying people and their gifts and getting them into the right place and having the leaders of the organization be very involved in that process. And so oftentimes in the nonprofit environment, that means that we're hiring people. And so we're wanting to make sure that we assess them correctly, that we do everything up front to help them be clear on what the expectations are for their role and for them as an employee, so that later on, if those expectations aren't met, then there's not room for the employee to feel like they were mistreated, and it doesn't create liability for the employer. We also want to be able to articulate the rights of a religious organization to discriminate based on doctrinal beliefs. Generally speaking, we know that discrimination is not a nice word. It's not something that we think should be happening for any reason. But we have to ask ourselves as religious leaders, do we want to be able to discriminate when hiring based on our beliefs? Do we want to be forced to hire if we're being asked to hire people who don't hold the same doctrinal values? And so the law does have some things to say about what rights an employer has to discriminate under things that would be considered protection of religious freedom and what things are not protected. So we're going to talk about some of those. Next, we also want to be able to identify and address discrimination in the workplace. There's lots of different types of discrimination, so we're going to talk about some basic types and what are the responsibilities of an employer in responding to issues that arise, issues of harassment or discrimination in any way. And then lastly, we're going to describe the steps that an employer should take when terminating an employee. So we're going to talk about what we should do to hire and what we should do when it comes time to fire, and to make sure that we're doing everything legally and in a way that protects both the organization and the individual. So let's talk about the hiring process. And I'm going to start by giving you two different terms. The first term is the type of employment that is most common in the United States, the employer-employee relationship. It's known as at-will employment. And basically, at-will employment simply means that as an employee, I'm here at my own will. As an employer, I'm employing this person at will, and either party has the freedom to terminate that relationship at any time, obviously within legal limits. You can't terminate for certain reasons, certain discriminatory reasons, but under normal circumstances within the legal limits, either party can terminate that relationship. So typically when you get a job somewhere, you're asked to give notice, but if you do something wrong, or if you feel like this is not the place for me, either your employer can say, we're going to go ahead and terminate your employment, or you as the employee can say, I'm going to submit my resignation, and you can terminate that. There's no contractual obligation to continue that relationship outside of a few things that that are required of the employer in the process of terminating. The contrast to at-will employment would be contract employment. And contract employment differs in that there has to be just cause for termination. So when it comes to the educational world, sometimes there's something called tenure, and tenure means that once you've become tenured, there has to be you're under a kind of a employment contract, and there has to be additional substantiation for terminating that relationship. Labor unions help to create contract employment. Probably one of the easiest ideas or examples of contract employment to understand would be with professional sports athletes working under contract as athletes. So, for example, the Denver Broncos decided they didn't want Tim Tebow to play for them anymore, but Tim Tebow had a contract, and so in order to release him, the Broncos were obligated to pay out his contract and release him from obligation to play. And so he was in some pretty funny commercials over the Super Bowl for T-Mobile about getting out of your contract. But contract is different than at will, because the Broncos couldn't say, "Hey, we're really not happy with the way you're playing," or we don't feel like you're a right fit. They couldn't just terminate him because of the contract. As long as he was within the limits and willing to do and perform according to his contract, then they were obligated as employers to keep their part of the bargain. So that's very different than at-will employment. So the main things I want you to know for the course and for your final is just the definitions of what constitutes being at-will employment and what constitutes contract employment. Really, the key thing is, do you have the ability to terminate at any time? Okay, so let's talk about some requirements for employers in the hiring process and in order to be able to hire. The first thing that's required in order to employ people is something called an EIN number. We've talked about EIN numbers before. EIN stands for Employee Identification Number, and it's essentially the same exact thing as a Social Security number. It's a 9-digit number, and it registers that organization with the IRS as an entity that has the ability to employ people. You will also need to have other numbers depending on the state that you're in. Each state has agencies that exist for the purpose of managing and monitoring employment relationships. And so in California, we have both the Employment Development Department that will issue a number to employers, as well as the Franchise Tax Board that will issue a number for state income taxes. So we need to get those numbers in order to be able to legally employ people, and you do that simply with forms. Second is that we are required to provide workers' comp insurance. So if we're employing people, we have to make sure that we have insurance in place that if that person sustains a work-related injury, that they would be covered by that. So these are legal requirements. Another requirement is to post employee rights information, usually using posters, and those posters have the current labor laws and OSHA requirements. OSHA is an organization that helps to monitor workplace safety, and so we have to post these disclosures in a highly visible place so that employees can see things like, what is the requirements for overtime, pay, what is the current minimum wage rate, and those kinds of things. Besides that, employers are also required to obtain a form called an I-9. An I-9 is basically a form that asks you as an employee to put down your personal information, as well as a couple of documents, like either your Social Security number and driver's license number, or maybe a passport number, but something that verifies that you are living in the United States legally and that you are eligible to be employed in the United States. So there are actually fines if employers do not obtain I-9 forms, and if for whatever reason an employee is flagged or questioned as being eligible, if the employer cannot produce that I-9 form, the employer will have some fairly significant fines. And so we're required to get that form as a way of verifying that this person that I'm employing is eligible to be an employee. We, of course, are not required to get I-9s for independent contractors who are not common law employees of our organization. But for an independent contractor, we need to get a Form W-9. And we talked about that before. And the W-9 simply asks them for their Social Security number, their address, and their signature, so that when you issue them a 1099 and you send one to the government, if they gave you a bogus Social Security number, you have a document that says that that was the number that they produced to you. And then in some cases, employers are required to do background checks. So in church, if we're employing people for the purpose of working with children, we of course are required to perform background checks for anything associated with children. And there are other kinds of employment responsibilities that also require background checks. So when you become a Foursquare minister, that's part of an automatic part of the process of getting your credentials, that you have a background check run at that time. So that can be a requirement, but it is not always a requirement. However, background checks are always a recommendation, because background checks are not only for criminal history, but they will look at things like, has this person had any financial defaults? Are there tax liens, associated with them? Sometimes there's wage garnishments and those kinds of things that are outstanding. And it's important to know that when you're about to employ someone, because that can create significant work for you as an employer if you're having to garnish their wages and all those kinds of things. So it's important to know what you're getting into as an employer. So another recommendation is to get an application with employment history. You want to know, where has this person been? What have they done? And ask them to produce references, and then check those references. Make a couple calls. What do employers have to say about this person's history? There are lots of horror stories to tell about situations that could have been avoided by simply checking some references. And so even if you think you know the person, even if they have a great interview, you still want to call and check, usually their most recent employment history. Why did they leave? Did they leave under good conditions? Did they burn any bridges and those things? Also recommended is that you give applicants notice of the terms and conditions of their employment. So this is helping to create an understanding of the expectations for the employee and what they can expect from you as an employer. So an example would be when you're hired, producing an employee manual that says, you get X amount of vacation, as part of your employment. And after, so many years of service, you're going to get more vacation. And this is how we handle vacation time. This is how we pay it out. This is how much you're allowed to accrue and roll over into a new year before you begin to lose the vacation. Those kinds of things. The terms and conditions that also help them to explain who the person that they're going to be reporting to is, or what department they're going to work for, and how you treat overtime and how you treat travel and those kinds of things. And addressing all of those things up front with an employee really help to avoid disputes later on when an employee may feel that they're being treated unfairly, or they're being asked to do something that goes over and above their responsibilities. If you can justify that all of that was disclosed and discussed when they were hired, then that helps to avoid those kinds of problems or disagreements in the future. And lastly, you want to have that employee sign an acknowledgement of the manual, saying that they've read all that information, that they understand it, and then you have that on file. That will protect you as an employer from ever having any kind of labor dispute later on. So key things that you want to remember is just make sure you get all the information necessary when you hire someone. Make sure you check that information out, and make sure that you have acknowledgement or verification that that was checked out, and that the employee understands the expectations that you have for them. All right, now let's talk for a moment about the special rights for a religious organization. There's a statute, Section 702 of the of Title VII of the Civil Rights Act of 1964, that says that a religious organization may discriminate in all employment placement decisions on the basis of doctrine. So, of course, there's tons and tons and tons of laws that prevent any employer from discriminating against people. You cannot discriminate on the basis of age or race or gender or all those kinds of things. Age within limit, obviously. But there is a provision for religious organizations to discriminate when it comes to doctrine. And so we are not, as a religious organization, as a church, we are not required to hire people who do not share our faith, our statement of faith. And so, very important component of that is that you have to have a very well defined and published statement of faith. And so, as the Foursquare Church, we have that. It's available on our website and clearly stated. Anytime someone is employed or credentialed, the first thing we ask is, are you in agreement with all of these doctrinal beliefs? This would also pertain to issues of discrimination on the basis of lifestyle and that kind of thing. That even though there are certain laws that exist to prevent lifestyle discriminations, as long as that it can clearly be documented or demonstrated that a person's lifestyle is inconsistent with doctrinal beliefs of the Bible, then this religious act, would be a protection for the organization to say, as long as the person, the applicant, is willing to make lifestyle adjustments to make sure that that falls in line with our doctrinal position, then under those conditions we would still be required to consider that person for employment, and certainly should. But if someone is having a lifestyle choice that is inconsistent with core doctrinal beliefs, then this particular act gives the church the right and the responsibility to discriminate on the basis of that protection. So anyway, hopefully that helps to answer any questions that you may have about the whole concept of discrimination. Outside of discriminating on the basis of doctrinal beliefs, core doctrinal beliefs, there's really no discrimination or harassment allowed in the workplace. And so let's talk about that. Let's talk about some different types of discrimination that exist, and the prohibitions. First, there's a prohibition against discrimination on the basis of pregnancy. You can't, when evaluating applicants, you can't tell someone, well, we're not going to hire you because either you are currently pregnant or you're planning on having children within the next couple of years, and we don't want to deal with maternity leave and all that kind of stuff. There are laws that prohibit that you have to treat everyone fairly regardless of pregnancy issues. And that would also be true of a husband in a relationship that may want to take paternity leave. There's laws that allow you to take maternity, paternity leave, and employers can't terminate your employment simply because you're taking that time off. There's also prohibition for unequal pay between genders. That comes from the Equal Pay Act of 1963. So if an organization has two people at a peer level, and one is paid more on the basis of gender and all other things being equal, then that organization can be liable for violating or for discriminating on the basis of gender. Sometimes there is unequal pay on the basis of seniority or experience or something like that. And in those cases, the employer is able to make a case for why there is a disparity in pay. But when other things are equal, then these acts really come into play and protect the employee from being discriminated against. There's also a prohibition of age discrimination. So you can't prohibit on the basis of someone being too old, which is really more common than someone being too young. Typically, if someone is very young, any discrimination that may be perceived is really more on the basis of experience. But for older people who have tons of experience, but are coming close to retirement age, this can be a problem, where they're not hired or they're treated differently or they're retired early simply because they don't have the longevity of career in front of them. And so there are laws that protect them against being discriminated in that way. There's also prohibition of discrimination for disability reasons. And so there's an organization called the American Disabilities Association, and they have an ADA Act of 1990 that says as long as the disabled person is able to perform the job, and this applies to hiring them, firing them, or advancing them in their role, they cannot be turned away as an applicant. They cannot be fired, or they cannot be limited in advancing in the organization if they're able to perform their job. And sometimes that even means with assistance. So there are times where you may have someone who's legally blind, or you may have someone who is in a wheelchair, but with the aid of certain apparatuses, like in the case of someone who's legally blind, there sometimes are special screens and things that they can work with that amplify to such a degree that they're able to read things if they're not completely blind. As long as they're able to do the job, then they would be protected against these discrimination acts. So those are the basic types of discrimination. And now let's talk about harassment, types of sexual harassment. And sexual harassment in the workplace is a very big deal. And there are three basic categories of sexual harassment. You're going to need to know these. And these are essentially the categories. First is quid pro quo. And you've heard this term before, quid pro quo, as it relates to contributions. And hopefully you all remember that quid pro quo stands for this for that. And so quid pro quo harassment basically means the same thing. It's this for that. In other words, if you do this, sexual favor, then you get that. You get advancement in your job, or we'll hire you, or you get some kind of perk or bonus in your job, or whatever it is. And so obviously, any type of advancements to an employee by an employer, propositioning them on the basis of reward is considered a type of quid pro quo harassment. Another type of harassment is something called offensive or hostile work environment. And offensive or hostile work environment can be anything from, telling crude jokes, inappropriate pictures or calendars or something like that, or teasing or anything like that. Anything that basically makes someone feel uncomfortable, whether or not it was directed at that person, whether or not that person even was intended to see whatever it is that made them feel uncomfortable. If someone encounters something of a sexual nature or an inappropriate nature that makes them feel harassed, then that can qualify as offensive or hostile work environment. And then the last thing is preferential treatment. Preferential treatment is similar in a lot of ways to quid pro quo, but preferential treatment basically talks about not so much the one who's being propositioned, but someone who's being passed over. Preferential treatment is when someone else is advanced due to having an inappropriate relationship with the boss. And so I'm after a particular job, and yet I get passed over because someone else is in an inappropriate or even a normal relationship with the boss. That person cannot receive preferential treatment because of that relationship, and causing me to be passed over or considered for advancement in the organization. So quid pro quo has to do with you're the one, when you're the person that's being propositioned, that's considered quid pro quo. If someone else is in a relationship and you feel like you're being passed over, then that would be an example of preferential treatment harassment. So those are the three basic things that I want you to remember as it pertains to types of sexual harassment. So let's talk about employer responsibilities. So employers must report especially if there are criminal acts that were committed, and but employers aren't necessarily required to report just on the basis of allegations that someone was harassed or that. They're required to investigate and build the facts. And if they've determined that truly someone has been violated in that way, then they're required to report. But if any kind of crime took place, like for example, someone was assaulted or someone was touched inappropriately or whatever, and then if any kind of crime has taken place, they're required immediately to report that to the authorities. Employers are also required to adopt a code of conduct that aligns to their statement of faith, in our case, or standards in the case of a secular organization. That code of conduct has to be clearly displayed. It should be included in the manual so that no one could say, well, I wasn't aware that that was considered inappropriate behavior. The code of conduct would explain clearly this is inappropriate behavior, and you will clearly know that you crossed the line because you have signed that you are aware of the code of conduct. We also, as employers, must have a policy, and we also must enforce that policy. So our policy is, if you violate our code of conduct, then this is the consequences. You're either put on suspension, or there's an investigation, or you're on a probationary period, or whatever, and we are required to enforce that policy. If an employee felt like they were in a hostile environment, or they were discriminated against in some way, even though the organization has a policy, if that policy was not enforced, that employee would have a right and reason to contact the authorities to say, hey, I'm being discriminated against on the basis that the employer is not taking my concerns seriously. Employer has to document everything. You, of course, want to keep those documents in a protected, safe file, because we don't want to violate anyone's privacy or anything like that, but we are required to document everything. Anytime there's a discussion, an interaction, an accusation, all of that needs to be documented. And lastly, it's important as an organization that we take remedial action. So again, we have some kind of policy that says probation or termination, or whatever the action is. We have to take that action and ensure the person who was discriminated against has a sense of being safe, and they know that they're being backed up. So those are the employer responsibilities. Some other responsibilities that an employer would have would include paying people. We have to pay people as promised. So if you are terminated, for example, then if you have sick or vacation time that is part of your compensation, that sick or vacation time has to be paid out to you. Whether or not you're at will or contract employment, if you are entitled to receive wages at a certain date, then you're supposed to receive wages on that date. Otherwise, it's considered a violation of the employer-employee relationship. Employers are also responsible to maintain a safe work environment, free of hazards, free of health and safety issues. You can't have you're supposed to have fire protection and smoke alarms and all that kind of stuff, and you can't require people to work in any kind of environment where they would be unsafe or exposed to anything that's unsafe. We are also required as employers not to ask people to do things that are not reasonable and prudent. So if you work in construction or whatever, you can't tell someone, hey, go walk out on that high-rise beam out there and fetch that toolbox. They have to have safety harnesses and all those kinds of things. You can't ask them to do something that a reasonable person wouldn't be willing to do. So asking someone to drive on an errand, if that's part of their job, that can be considered reasonable and prudent. So there may be times where someone has a phobia or something like that, and you're asking them to do something, and they're saying, well, no, you're harassing me because I don't like to drive. Well, that's not considered harassment, because you're not asking them to do something that's unreasonable or unprudent. It's a normal part of the job to run errands. So that would be an example of the opposite. And of course, we're responsible to maintain insurances and licenses and all the things that we're supposed to have in order to operate our current organization. All right, we're rounding the corner here. I'm going to talk about termination, and then you'll be done, and we'll let you get on to the midterm. So when it comes time to terminate, what are the responsibilities of an employer? One of the first things that we want to do is, as employers, we're always responsible to give a warning and document, if possible, when someone is at risk of losing their employment. There are occasions when you don't do that. For example, if someone committed a crime, like for example, if someone physically attacked another person in the workplace, you're definitely required to document what happened, but you are not required to let them off with a warning. If someone's committed a crime against another person, you can terminate them immediately. But within reason, if someone has done something that is grounds for termination, before terminating them, you want to show that you've given them a reasonable warning and an opportunity to change that behavior before terminate. Otherwise, if you haven't, if that person can reasonably prove that they were not aware that that was an expectation, or they were not aware that their performance was not up to par, then they might be able to get a court to rule in their favor that they were wrongfully terminated. And of course, we don't want to wrongfully terminate people as religious organizations, and nor do we want to be liable for wrongly terminating people. Second thing is that you want to try to have an in-person meeting rather than doing everything by writing. You always want to have an opportunity for that person face-to-face to ask questions, to get clarification, and also it's just a much better way to conduct things in a loving way, in an interpersonal way. And then next, you also want to make sure as an employer that if you're ever terminating someone, you issue them a final paycheck. That final paycheck needs to include all of the pay that they're entitled to for the hours that they've worked, along with any unused benefits that's part of their contract or their employment contract as per the policy. This is even true of at-will employees. Even though you may not have a contract, the policy that comes with the employee manual can be considered a form of contract. It's the agreed upon benefits that they are entitled to as part of their employment. So if they're entitled to a certain amount of sick time and vacation time and they didn't use that prior to being terminated, then the employer is required by law to issue them the financial equivalent of that vacation and sick time. And the last thing is to discuss if in situations that hopefully will never happen to you, where someone feels like they were wrongfully terminated, or there's any kind of employment dispute, you always want to investigate the possibilities of mediation or arbitration instead of court. Mediation and arbitration are essentially when you have a third-party mediator help to assist you in coming to a settlement or a conclusion without going to court. Arbitration is when you involve an actual, usually a retired judge or someone who's a court-appointed mediator. Mediation can be outside of the court system. And many times in the employee manuals, that is something that is disclosed as a condition of the employment, is that if there are disputes over the terms of the employment, that first you would go to mediation or arbitration and try to settle that way before anything would go to the court system. So that's really it for human resources and church employment. So again, just a quick recap, important things to know when hiring people. First of all, the type of employment relationship, at-will employment or contract employment. Know what the requirements are for employers. We have to obtain the appropriate numbers and authorizations from the government agencies to employ people. We have to also verify that they're eligible for employment. It's important and recommended that we do things like due diligence, background checks, reference checks, those kinds of things. We have to understand that we cannot discriminate as employers. We cannot be discriminated against as employees. And the only basis of discrimination in a church setting would be on the basis of doctrine. And so as long as individuals in our organization hold the same doctrinal beliefs, the core biblical beliefs that we do, then they cannot be discriminated against. It's only on the basis of differences in doctrine or differences in theology that that type of discrimination is legal, and churches are have that to stand on as a religious protection. And then also remember just some of the responsibilities of the employer, to maintain safe workplace, to have policies to protect the employees against harassment, to have a way of enforcing those policies, and lastly, if someone is ever terminated, that you follow good protocol, or ensure that if you're an employee that ever gets terminated, that you were treated fairly in that process and given opportunities to change whatever was unsatisfactory. So hopefully that gives you the basics of HR in about a 30-minute session. I want to wish you all good luck on your midterm. I'm going to be praying for you that you do well, and I'll look forward to seeing you again next week, and we'll follow up on any questions, and I'll return your papers to you at that time. So thanks again, Jared. God bless you guys. Have a nice break, and do well on your midterm.